Most creditors, when you're dealing with credit card debt, they'll have a minimum amount that they're willing to accept that they give to the law firms. So they'll say, hey, here's our cutoff percentage. We cannot go lower than this, but this is our target amount that we're trying to collect, right? I'm curious if it's the same for medical debt collectors. Do they have cutoffs and percentages that they say we can't go lower than this amount, but if the debtor can pay this much, then we will accept within this range? What does that look like? How much do medical debt collectors typically settle for?
So that was never my experience, right? In my experience, it was always a case-by-case basis. And I think it's important to remember that ethically, the decision to settle lies with the client. So it was never my decision to settle a case or not. However, they're always going to listen to me and defer. If I tell them to do something, they're usually going to do it. And so, yeah, while there may be, creditors that are we'll never go below this amount, I actually don't think, as a creditor or a creditor's attorney, I think if you just set hard limits and this is what we do on every case, I don't think you're doing a good job. Like I said, every case is going to be different. And it may be on case A, you've got a really solid case with all of your documents lined up. You've got witnesses that can come testify and lay a foundation for those documents at trial, and it's really solid. Case B, it may be, look, I'm missing stuff and I'm trying to, intimidate them into paying me, but I know if I go to trial, there's a reasonable chance I'm going to lose. And if I'm not adjusting the settlement amounts on those, then I don't think as a lawyer I'm doing a good job. That was how I felt on the creditor side of it. So we didn't usually take this approach of, we'll always go down to, we're always aiming for 50%, but we'll go no lower than 25%. That was never the approach that we took. Now, certainly there are creditors out there like that. But the other thing I would say is, they can say that everything is always negotiable, right? And I've seen a lot of cases where they'll say, we'll never go below, 50%. We just won't do it. Okay, well, what happens when you get a judgment and you start to try and garnish their wages and the wages can't be garnished? Maybe you're in a state that doesn't garnish wages, or maybe this person doesn't have W-2 income, they're on disability or something, and they come to you and offer 25%. As a creditor, you have to think long and hard about taking that, even though you have this I'll never drop below 50% rule, because you can say, I'm going to stick to my rule no matter what, and you'll get $0. Or you can make an exception based on the facts of that case and get at least 25%. So certainly it happens that collectors set those rules. I don't think they're doing a good job personally.
So basically what you're saying is, even if a creditor has certain limits that they'll accept for a settlement and a threshold that they're trying, a target amount that they're trying to collect, it sounds like most debts are still negotiable, even if there are those limits set.
Yes, and it just may take time, right? Because they'll say, we won't go below 50% or whatever their number is. There's nothing you're going to say to change their mind at that point. Yeah. Well, what can you do to change their mind? Defend the case, go all the way through. And if they start to panic and think, oh my gosh, we might lose this case, that number might go down. Or maybe they beat you, they get the judgment, and then they have a hard time collecting it. And you offer them a little bit of money that's below their limit. Maybe they'll take that because the circumstances have changed. And they're trying to maximize the amount of money that they collect based on the time that they spend. So while they may never drop below that limit early in the case, they might drop below it later.
Gotcha.